This conference will now be recorded.
Take it away, Amine.
Great. So we have 10 people on the line right now, and hopefully a few more are going to trickle in here. Well, welcome everybody to Family Business Atlantic Staying Connected webinar series. I am Amine Mousavi, the president of Family Business Atlantic. And for those on the line today who may not be as familiar with our association, we connect and support families in business, small, medium enterprises, and entrepreneurs to help drive the Atlantic economy. We also offer safe and confidential forums for our members to share their business challenges with and learn from peer groups. We also provide programming platforms like this with the support of our trusted advisors. With COVID-19, these certainly have been challenging times for our businesses, our staff, and of course, all the families involved. These webinars, we've been able to connect together and reinforce a key message that we are not alone. We've been providing webinars to address relevant issues such as today. And also, I'd like to invite you to attend our coffee chats that are happening every second week for some real-time conversations. So please do continue to take advantage of our offerings. Today, we are very pleased to have HR specialist Sean Kelly with Stewart McKelvey back with us. Sean has been very busy working with his clients these days to address the so many new and unusual situations businesses are facing as we reopen the province. He'll be speaking to the changes in the employment law world and will update business owners and their staff on what they can expect in the upcoming months as we continue to conduct business in a world where the word COVID is still upon us. A little bit about our presenter. Sean is a partner at Stewart McKelvey, Halifax's office, and he practices management-side human resources, employment, and labor law. He works with employers across a wide variety of industries and provides timely, strategic, and practical advice. Sean regularly defends employers at all levels of court in Nova Scotia, and he handles all aspects of employment and labor law. In addition to his busy practice, Sean is vice chair of NASCAD, and he is a sailor and a surfer. Fun fact about Sean. So before we get started, I'll ask you all to mute your microphones, but you can ask your features during the presentation on the chat feature, which is at the bottom of the GoToMeeting screen. We definitely want this to be an interactive webinar, and after the presentation, feel free to unmute your mic and ask questions as well. I guess with that being said, Sean, you can take it away.
Sure, thanks everybody. My plan is to take about 40 or 45 minutes today to go through kind of some high-level issues that we're facing, questions that we're fielding as counsel to employers in all kinds of different industries and businesses, from small family business to large publicly traded companies. The issues are quite diverse, but there's also a lot of commonalities. First thing I am going to observe is that there is no roadmap, because we are in highly unprecedented times, and this has never happened to any of us before. I don't think, at least that I'm aware of. This is, truly unique. Significant economic impact is really impacting every business a little bit differently. But some common themes I'm going to talk about. So one of the big things we're dealing with is physical health. So the first consideration as people start to come back to work, and I suspect a lot of you have people working from home. I suspect a lot of you are also continuing or trying to continue operations, business as usual, to the amount or to the extent that you can. But so the first big thing to consider and that we're advising on is assessing physical space. So employers have a general duty under health and safety legislation to protect people at or near the workplace. So what does that mean? I look at what we've done here at Stewart McKelvey. We've got, we've changed our physical space and the rules by which people inhabit our physical space at work. So who comes in when, staging entry in terms of time for coming to work, controlling and monitoring the number of people in your workspace, changing physical space. So all of our hallways now have little arrows. Each of our rooms, I'm in here with Candace, we're 6 feet apart. We've got these in every room, limit 4 people, and this is a massive boardroom. So it's important. It's important to make sure that to the extent that you can, that we are abiding by physical by the physical distancing rules, supplies, masks, hand sanitizer, that sort of thing. The medical information from employees, always a really dicey one. Medical checks. So as you will all know, there are human rights concerns that play into all of this. And it's important to remember that just because we're in a time of COVID, it doesn't make human rights obligations disappear. So you know, are you entitled to specific medical information? Well, the answer is that it depends on what type of information you're seeking. If you're asking somebody if they have COVID symptoms, definitely. We have signs posted on each floor when people come in. If you have any of these symptoms, you are not to be here. I'm going to my physiotherapist often, and I get screened every time I go in there. So, you know, it's important to ask those questions and make sure that you're, you know, taking all reasonable steps to ensure health and safety of people at work. I'm going to move on to scheduling now and talk a little bit about that. So in terms of having people come back to work, again, we're operating not at 100%. We still have a lot of people working from home. The return will be gradual and probably over a period of a number of weeks. And for some people, if at all, right? So some people may be able to do this from home. There may be childcare reasons why you want to allow them to do it from home. You know, who comes in first? I think the real question there is, who do you need first? You know, who is imperative, who's mandatory, who's functioning from home and who's not. I will tell you, I am horrible at working from home. I don't like it. I'm not good at it. So I have been back in the office. I never really kind of left. I was always back and forth. And I guess the good thing in that is that I don't really wear suits anymore because I don't see any clients. But you know, who is in first? Who do you need first? And then how do they interact with people working from home? The vacation question is a massive one, and we deal with it all the time. I guess bottom line, COVID was not a vacation. It may have been people not at work, but I don't think it was fun for a lot of people. There was a lot of uncertainty. People were home with kids. People were home way more than they probably ever expected to be. And so, you know, yes, you can force people to take vacation, but you really should be careful about that. I want to highlight that the employer is the one who manages vacation. So it's the employer who can say, you get to take vacation now, or you don't get to take vacation now. But that being said, I don't think you want to be saying, unless there's good reason, oh yeah, you've used up all your vacation time, and you know, therefore you don't have vacation. That said, you know, you want to probably, and I've had a lot of clients in small businesses say, well, I can't have half my workforce off in August when they're just coming back to work. So, you know, I think it's strategically, you probably want to work with, we want to work with employees to come up with a mutually convenient way to schedule and manage vacation time. So again, jump in if there's any questions. I can keep talking, but yeah, and I'm going to start sort of answering some of the key questions shortly after this slide. So if you do have questions, specific questions, please don't hesitate to jump in.
There's a little chat thing.
Oh yeah.
There we go.
Okay, great. And now I can see where the questions are going to come up, so that's helpful. Reorganization. So that's another big topic. I have heard many people, you know, business leaders say, you know, never let a good crisis go to waste. And I think that that's actually really true. COVID, you know, rightly or wrongly, and I guess I say that wrongly because we should also always be looking at what efficiencies we can make. But COVID has really given people occasion and an opportunity, or has forced them to look critically at at, you know, who are their key people, and you know, will you continue to feel negative impacts? Who comes back? Has COVID opened up new ways to move forward? Will you require fewer people? I think it's possible. Will people be expected to change their roles and responsibilities? I think absolutely there's going to be, you know, a lot of flexibility that is expected, and I think courts and tribunals will, and through governments, will be receptive to those, to that need to be flexible, so that we can simply, you know, keep our economies going. It's very, I would, you know, I don't think we've felt, probably they keep saying that, you know, this is, you know, we're not going to feel effects. We haven't felt effects like this since the Great Depression, and that could very well be true. I mean, hopefully the rebound is swift and consistent, but you know, we don't know. And so, you know, does this give you occasion to sort of reorganize? I'm having a lot of people I'm having a lot of people ask, you know, questions. We're doing a lot of kind of, you know, changes to employment agreements. We're doing a lot of sort of workforce reorganization and giving advice on that. So just had a question: what if you can't physical distance? Good question. You know, it'll be interesting to see what the comments are in terms of the group of 10 people. I think that's not employment related. I think that's socially related. So, you know, what we've done here at Stewart McKelvey, and this is by no means, you know, rightly or wrongly, if you can't physical distance, then you need to wear a mask. I think, you know, you need to be very particular with following the rules. If you can't, you've got to put some other form of protection in place so that you are able to say that you've taken all reasonable precautions to ensure health and safety of people at your workplace. The other option is to get an exemption or seek an exemption from Dr. Strang's office, and we've had that. I wouldn't be flouting physical distancing rules unless you've spoken to an occupational health and safety person from the Department of Labor. So I'm going to keep moving on to the last key theme, and that's mental health. So we can go to the next slide there. So COVID hasn't been fun for anybody. It's been, and I say it as if it's over. We don't know if it's over. We know that it's subsided for now, and at least in the province of Nova Scotia, and we're very fortunate about that. But they're anticipating more waves, whether that's second, third, fourth, or fifth. We don't know. But it's been a weird and an uncertain time for a lot of people. So, you know, certainly with respect to employment, I think there are a lot of people, I know there are a lot of people that are in quite precarious positions. So what messages do employees need to hear about feeling safe? I think that is really communicating everything you've done to make sure that you're following the rules, and that is about all you can do. Otherwise, people are otherwise going to have limitations about returning to work, or they're going to have reservations. I think, you know, you need to decide whether working from home is something that's going to work, or you need to reintegrate people back into the office. Again, subject to the duty to accommodate, you can require people to come to work. So the other issue that we're seeing a lot of is, you know, potential friction between employees who may be coming back, or those that may have been brought back before others, or those that have been laid off and their jobs have changed. So, you know, there is a lot of change, and change makes things uncertain. The other thing too is that the workplace is really where a lot of personal problems tend to manifest itself. So what I mean by that is, if people are having problems at home with you know, spousal or partner issues, or you know, substance abuse, or any number of things, those can manifest themselves at work, and particularly in a high stress environment. Like, who knows whether their spouse has been laid off, did they have work, has their job changed? We're seeing a lot of mental health components of I shouldn't say components, but mental health effects that are resulting directly from COVID, or from the changes that we're seeing in the employment world as a result of COVID. So what I'm going to do now is move on to some questions. Some of these are questions that you guys asked asked directly, can mandatory vaccinations be enforced at work? Yes or no? It's a really good question. I'm not sure there's a super clear answer. We know, and as I reflect on this, there is some pushback from some groups of people and individuals about not wanting to be vaccinated. I think that, we're probably going to see litigation over this where people are refusing to be vaccinated, and they're saying that they've got either religious or other reasons for not wanting to be vaccinated. I think that's a tough sell given where we are, but I do suspect that that employers are going to have to kind of go. I think there's a baseline expectation, and I don't think most people would resist to a vaccination. I do think it will be an interesting test as to whether or not refusal of a COVID vaccination or refusal to be vaccinated would constitute undue hardship. Michelle, to your question, I'm not aware of any. I will admit it's not something I've looked into, but I would say, I would be confident litigating this. I don't know whether we'd win or not. I think it would depend on who the judge is, but it's a really tough question. I would be taking the position that you are going to see that that there's going to be a baseline expectations that people will submit to vaccination. Another question, do you have to notify staff if someone in the office is getting tested for COVID? I don't think you have to notify them if somebody's getting tested because the symptoms are so broad. I do think that you have to notify somebody if somebody tests positive for COVID. So not the test, but the positive result, you would have to notify. You try and keep that identity as confidential as you can because it's not really a public thing, but so short answer, you don't have to let people know about the test itself, but you would have to let people know, and I think encourage them to call 811 in the event that they were tested. So going on to the next slide, what rules have been modified since COVID-19 for both employers and employees? Broad question. I would say everything. This has changed the water on the beans for employers and employees. So we've seen other so by way of one example, when this first started, we were dealing with all kinds of employers needing to kind of shut down or making the decision that they were going to lay off large numbers of employees. And in the employment standards, the labor standards code, there's a provision that says that you don't have to give notice as long as, or in the rare event that this is something that is truly beyond the control of the employer. And our advice and our interpretation of that was that has to mean something. And if it doesn't mean something now, it doesn't mean anything ever. So that's one example of kind of rules or exceptions to the normal rule that we've been invoking. Governments in Ontario and New Brunswick have said, yes, that does mean something, and this is a case where you don't have to give notice. I would also say your obligations at common law, and again, this is a little bit in the past because I think we're really in the business of sort of ramping up now as opposed to winding down, but the obligation to provide pay in lieu of notice kind of at common law or for court-based notice is something that we had seen kind of temporarily. We had been advising to that, in this situation, you don't have to give that because the contract is basically temporarily frustrated or temporarily impossible to perform. So I would say that that's a big one. So it's sort of the right to severance or temporary layoff is something that we were quite, we're relatively, I wouldn't say aggressive about, but if there's ever an exception to the normal rules, this was a time that you would have to do it. So our workplace modifications being enforced is the next slide. And I guess I read that question as, are the social distancing rules and the required distancing obligations being enforced? I think absolutely, and I think you've got to take them really seriously, because there's fines of up to $7,500 for each business, the $1,000 fines for individuals. We have seen some of those be issued, if you're following in the news. So workplace modifications, i.e. are the social distancing rules being enforced? Absolutely, and I think it's incumbent on us and on you as employers to make sure that you're setting yourself up for success. The last thing you want is the press or the publicity of dealing with those non-compliance issues. So that goes into the next slide. What are the penalties for non-compliance? Fines of up to $7,500 per occurrence for an employer, $1,000 for an individual. Next slide. If an employee can do their job remotely, are they legally able to do so even if the employee wants them back? Good question. Seeing it all the time. The answer, in my view of the world, is no, because you get to decide who works from home. Working from home is a privilege, not a right. I would say this, though, that you know, you need to think about it from a legal perspective and from a morale perspective. So there is the duty to accommodate, and childcare is a big one in all of this. So can an employee work from home? I would say, and I've been talking to a lot of clients about this, that if you can have somebody work productively from home and there's a reasonable basis or justification for them to do so, it makes perfect sense to me to let them continue to do that. But working from home does not mean that you have an obligation to compromise your expectations on productivity or anything else. So if somebody is just not productive from home, you can tell them they need to come back to work. If they say they can't because of childcare obligations, then we can have a different discussion, because there is the duty to accommodate, but it only goes so far. And, you know, working from home doesn't change the water on the beans that you are entitled to, you know, productivity in turn from the wages that you pay somebody. Going to the next question, how is sick time during COVID-19 being handled? Are vacation privileges still the same if someone has been off work for 3 months? So unless people took sick time, excuse me, unless people took sick time during COVID-19, I would be maintaining that sick leave. And our vacation privilege is still the same if someone has been off work for 3 months. My view is yes, they are, unless you had them taking vacation time or advised them that they were using vacation during that 3 months, then yes, that vacation entitlement, because vacation accrues as people work, right? So if you haven't told them that, oh yeah, well, you're taking vacation or this is vacation in real time, I think you're going to face a problem if you say, oh yeah, by the way, while you were off, I you know, vacated your vacation bank, if that makes sense. Next question is an interesting one, and I was thinking about this last night. Vision of tomorrow's workplace, short and long term. That's a good question. I think we have the short-term picture right now, and you know, I think there's going to be a lot of flexibility. I think we've seen some people work well from home. We've seen some people prefer to work part-time from home and part-time from the office. I think flexibility will be a big one, and I think more relaxed expectations of needing to come to the office. What I would say is that doesn't mean more relaxed expectations with respect to productivity. And I guess that sort of feeds into the longer term. I mean, I think you're going to see a decreased demand for what is traditional office space, and offices are probably going to work. So right now, so we recently moved from Purdy's Wharf into Queen's Mark, and my office went from 17 by 15 to a 10 by 10. And so that was an interesting shift. And, you know, so we were already sort of trending in that direction. I think you're going to see people less and less dealing with traditional offices per se and sort of working more from hubs. I think you're going to see redesign of office space. And I think sort of flexibility will be a big one, again, not at the expense of productivity. So those are the questions that you guys submitted. I'm going to go through a few of the key ones that we're dealing with now. But again, if anybody has questions, please jump in. How far can we go on changing terms and conditions as part of a return to work process? The answer is, in classic lawyer form, it depends. So, you know, we have routinely been saying for years that you can change somebody's remuneration by 10 or 15%. Again, you're going to want to get advice before you do that. The real question here is constructive dismissal. So are you fundamentally, in a unilateral way, without notice, changing somebody's terms and conditions of employment? So whether or not that is fundamental is really a legal question. Some of you may recall that last time I was talking about a Court of Appeal decision that I have on constructive dismissal. Really, I think that this has given employers or will give employers a bit of a leg up in terms of the degree to which they can change terms and conditions of employment, particularly if they can show a reasonable justification for doing that. So I think courts are going to start to be more receptive to these changes, and there's going to be a baseline expectations for employees to act reasonably in accepting changes to their jobs, largely because at the end of the day, there's an awful lot of people who've lost their jobs as a result of this, and an awful lot of folks who've been sort of, I will say, crippled, I guess, because of this. And so if you're not willing to accept some degree of change, I don't think that's going to go very well. So how far can we go on changing terms and conditions of employment? Do we have to recall the most senior employees first, or can we recall the best people first? Good question, and a very important one. Unless you're in a unionized environment and subject to a collective agreement that has specific recall rights, there's no obligation to provide to recall the most senior employees first. Now, I say that with one caveat, that you can't decide not to call all the people who are 65 and above back to work and bring all the 20-somethings back, because, you know, I think I would caution you on that. You have to have a really good reason why. So subject to not doing it for any reasons connected to a protected characteristic, so age, sexual orientation, gender identity, religion, all of those sort of protected characteristics under the Nova Scotia Human Rights Act, you don't have an obligation to bring the most senior employees back first, and you can recall the best people first. Now, we're dealing a lot with that in a bunch of different industries, and so the idea is, I think you need to be looking, and this is really a practical question, is you need to be looking at who comes back first, who's adaptable, and who's flexible. And again, you just need to keep those protected characteristics out of them, unless you're in a unionized environment. Next question is about employment agreements and having people enter into new contracts as part of the return to work. You can. I don't think it makes a whole lot of sense, to be honest. I think practically you're better to adjust their job description upon a performance review or something to that effect. I wouldn't be going around having people sign new employment contracts per se. But I would be suggesting that you do make some changes if you do have a standard form employment agreement, which I think you all should, that you make some changes as a result of what's happened in the landscape as a result of COVID. So some examples of that would include, maybe you've got a temporary layoff provision in there. Maybe you've got a complete exception to the obligation to provide notice in the event of, you know, a third, fourth, or fifth wave, or a second wave. Again, I wouldn't be imposing these in previous agreements unless you time it with a performance evaluation. But I would be revising your standard form employment agreements to reflect the realities that COVID has brought to the world of employment. There was one more slide about COVID and the impact on mental health. Is that still there? I think if we go back one. No? No. Okay, it's not in there. So the question is, We know COVID is having an impact on mental health. Do we have an obligation to ask employees how they're coping? And it's a really good question. And it used to be that the duty to accommodate and human rights obligations did not require, they required an employee to sort of speak up and say, hey, you know, I've got a broken leg, or I'm suffering from, you know, anxiety, or I've got, you know, some other mental health issue. It used to be that it was the employee's obligation to raise that with the employer. As a result of sort of increased awareness of mental health, the laws changed a little bit to require employees or employers to, it imposes sort of what's called a duty to inquire in the event that somebody doesn't appear to be coping well. So, you know, you can't sort of hide behind the, well, I didn't know. So the question is, did you know, or ought you to have known, or should you have known because of X, Y, and Z? So it's really not a super onerous obligation. And I think, you know, we're saying just ask people generally if they seem off, ask them if they're okay. Remind them about the availability of the employee assistance program if you have that, or other benefits that may be available to them. So next question, covering expenses for employees working from home. I don't think so. You know, you're not going to start paying for people's heat or their electricity bill. I do think that if somebody asks, or if somebody is working significantly from home, then you can fill out what's called a T2200 and allow them to write off some of the cost of their home office. But do you need to pay for power in the home office? I don't think so. You know, the other question that comes up is ergonomic chairs and all of those sorts of things. I think, you know, maybe to some degree you would want to consider that, or providing some sort of allowance. I wonder if you know, some form of ergonomic assessment makes sense. You know, depending, we're seeing a lot of employees take office equipment out of the office, or we saw this, and bring it home to their home offices. That just makes sense from a productivity standpoint. I see there's a question here, can employers reduce or freeze wages due to COVID and the remuneration impact? You can do whatever you want, but there's always some risk. So freezing wages, I don't have a problem with that. I mean, everybody has taken a bit of a hit with this, or has taken a hit, or a significant hit. I think you can reduce wages to an extent. We were dealing with this question a lot a few months ago, where employers, we used to say that a 10 or 15% decrease in remuneration was not sufficient to get you to the constructive dismissal threshold. Employers were, and I've seen reductions of up to 25% in some workplaces. The key thing is that, you know, the employees aren't going to like it. Can you do it? You got to do it so that you treat everybody sort of equally, would be my suggestion. And the bottom line is that employees would have a duty to mitigate by sticking around. So they can't just walk away. And this was what my Herald case was all about. They can't just walk out the door once they say they've been constructively dismissed. So they have, unless it's a humiliating or toxic work environment, they have to stick around. So even if you reduce that income, your liability or your exposure at the end of the day is effectively going to be, what was the difference had you provided proper notice of the reduction? And I do think, you know, we are definitely going to see that being litigated at some point. You know, I think we'll see to what extent that reduction does or doesn't constitute a constructive dismissal in due course. And there's the question I just answered, so we can go to the next one. What are some tips on steering through a crisis? So I talked about this a little bit earlier this morning in another presentation I did. I think the only thing that we can know for sure is that everybody is doing their best, and that this is truly unprecedented and very strange times. I think one of the big things is don't overreact. Have a plan for re-entering the economy, or re-entering the workplace, sorry. Have a plan in case somebody does turn up. I would say be cool, and be thoughtful and be transparent and don't overreact would be the big buckets to keep in mind in the event that there's a crisis specific to your workplace. All we can do is our best, and all we can do is follow the rules. And so, as long as you're doing that, I think, and you can show the work you've done to do that, that's the best we can do. When does a layoff turn into a termination? So under the Labor Standards Code, you can lay off for up to 6 consecutive days, and then it's deemed to be a termination. At common law, we don't know the answer to that yet because we're still in the middle of all of this. So we'll know the answer to that after the effects of COVID are over. I think we are again going to see a lot of litigation resulting from people who were let go or laid off and not called back after all of this ramps up. So we'll see some commentary from the courts on that. But I think, we'll know down the road. But effectively, under the Labor Standards Code, a layoff for more than 6 days is a deemed termination. We'll see what happens and how fast we can get back to all this. Employee returning to work after they identify they have an autoimmune disorder, do you make an accommodation to keep them working from home? I think the short answer is yes, as long as you can. But there is an undue hardship component. So if that person can't work from home, you're not going to have them paid at home. So if they're working in a manufacturing facility or something where it's completely unpractical to have them working from home, you're going to have you're already going to have laid them off. So as long as it's productive for them to continue to work from home, I think in this case, for the foreseeable future, you would keep them or would permit them to work from home as part of the accommodation process. What can employers do to mitigate the risk of workers' compensation injuries due to workplace injuries working from home? So this new sort of phenomenon in working from home or working remotely doesn't take away from the normal workers' compensation coverage, which applies to injuries that arise out of and in the course of employment. So it's not going to be you cut your thumb making a sandwich for lunch. That would not be a compensable injury under workers' comp legislation. But if you were in your home office and something fell on you, or if you were, you suffered a carpal tunnel or something to that degree, then you likely would be eligible for workers' compensation benefits. And I don't say that as a bad thing either, because the workers' comp coverage, and I know workers' compensation premiums are expensive, but what it does do is it eliminates the ability of the injured employee to come and sue you for civilly for injuries that happen in the workplace. So what can you do to mitigate the risk? I think we've been doing a lot of work on work from home policies lately. So making sure that employees are doing risk assessments and signing off on those risk assessments that they've completed them of their home workspace. And so that's really the key thing, is making sure that you've turned your mind to health and safety at work when people are working remotely, and had confirmation from employees that they have carried out that. What's that? What? Oh, I don't care. I'm fine.
Okay.
I've got my colleague Candace in here, and she's trying to organize my papers, but I said I'm fine. It's fine. I don't need that. All businesses required to have a pandemic return to work plan, or only those that were mandated to close? So you're not required to, but I think it's in your best interest to do so, and to have a plan or an idea set up of, okay, what are we doing here? What are the rules? How many people are allowed to be here? How many people can fit in this room? How many people can go down this corridor? What are we doing for the elevators? Are we staggering hours of work? Are we not? So it's more than the bars, restaurants, physiotherapists, hairstylists, etc. I think everybody's well advised to have a plan. Next question. What do you do when staff are refusing to return for health and safety reasons when you're meeting safety standards? I think it's explained to them what the obligations are, and explain to them everything that you have done to abide by those safety rules. And I think that, we're taking the firm position that people need to come back to work unless there's a darn good reason otherwise, if you say so. And so, what do you do when they're refusing for health and safety reasons for safety standards? I think that has to be a legitimate and kind of bona fide, reasonable request, and they got to have a darn good reason. So if they're immunocompromised themselves, probably want to consider that. If they just have been off on CERB for the last 3 months and they think that they want to continue to get CERB when there's work available for them, I'm advising to take a super hard line on that, because there's no entitlement to if there's work available, they ought to be taking it. Same answer to this next question, and this is a common one of people having anxiety about getting back to work. I think it's highly important that you show what you've done, and as long as there's no darn good reason otherwise, people need to come back to work unless you've decided that there's no need for them to, or you're okay with the level of productivity working from home. Obviously, there's human rights concerns, and I think we're going to see a lot of claims where people have decided that it's important for somebody to come back to work, but they're refusing to do so and evaluating the reasonableness of their specific requests. Next question, got about 10 minutes left, so if you do have questions, please let me know. Changes to standard employment agreements, sort of already answered this one. But I'll go into a little more detail. So I think we need to be building in flexibility into employment agreements, the ability to lay off temporarily and not have to provide notice. We're seeing a lot of what constitutes frustration of contract. Does a pandemic constitute that? I think it has to, but I think turning your mind to that. And I also think increasing flexibility or the ability to change job duties to meet the needs of the employer going forward. I think those are going to be very common clauses. The next question, daycares are reopening. What if parents are not prepared to put their kids in daycare? Again, there's got to be a pretty darn good reason why not. So important to have that discussion with whoever the person is, and find out why. But if we know that daycares are not at capacity right now, and that's because a lot of people are still working from home, and maybe they have permission to do so, and maybe they're not, or they just don't want to. But I would be, subject to any human rights considerations, I would be following up and saying, well, why not? And people had kids in daycare before. The daycares are deemed to be safe. People should be going to daycare. Next question. We talked about this a little bit. So reimburse expenses, I think only in special occasions, to be honest. And I think this idea of the T2200 is a really good idea, and it helps people, gives them a little bit of a financial break in terms of the T2200. How should we handle return to work of an employee who's tested positive for COVID-19? Great question. Make sure that they're medically cleared to return to work. Once somebody is cleared by their physician, it's hard for you not to have them, it's hard to have them not return to the workplace, and it's hard for them to justify otherwise. I think, the return to work of an employee who's tested positive, as long as they're asymptomatic and have been cleared, then there's no issue. And I think the tougher question is, what do you do for an employee who's been tested? I think you've got to wait until you get those test results. What do we do with minimum wage employees who prefer CERB to returning to work? You tell them that there's a job for them, that they're expected to return to work, and if they say they want to take the summer off and there's no reasonable justification for bringing them back, then you terminate them. There's no reasonable justification for them to continue to refuse to work. What do you do when both parents are claiming they need to stay home for childcare? Call them on their on it. Be careful about what information you disclose and how you found that out. But there's an obligation to cooperate with employers, and I think far too often employees tend to try and take advantage, particularly of in the CERB situation. I think it was a beneficial program, but it's one that is very easy to take advantage of because of the huge variety of claims. Can you insist people not travel on their personal time to avoid required self-isolation periods? I think you can, I don't know if you can insist, but you can highly recommend. And I think if people are going to have to self-isolate and they can't work from home, you don't have to pay them for that 14-day time, because we're really not supposed to be traveling as it is. And I think you can, if somebody says that they were going to Ontario and then back to Nova Scotia, I think you've got to be very clear with them as to what your expectations are, and is that trip truly essential? Do you want to, excuse me, prevent somebody from going to see their, ailing mother in Ontario and then not pay them? Probably not. But if it was to go to Canada's Wonderland for the weekend and then come back to Nova Scotia, I would think that that's probably a little bit indulgent at this time, and they should probably just go canoeing in Keji instead. So how do you police social distancing workplace protocols? I think you make it a rule, and you can discipline up to and including termination if people are not following the rules and are being quote unquote difficult and just not obeying the rules. And I've seen it many places, people sort of flouting the rules. I think in order to be above board, you need to be very diligent to make sure that that whatever the public health authorities are saying is being followed in your workplace. 2 questions left. All or part of our workforce is now working from home. Do we have to pay for desks, chairs, and other equipment that will reduce potential injuries? You don't have to, but I think it makes a lot of good sense to follow up and make sure that people are able to comfortably and productively work from home. And I wouldn't say pay for it, but if somebody's going to work from home and you don't anticipate recalling them till September, why not offer to have their office chair sent to them and their dual computer monitors and that sort of stuff? It's really, you're trying to make sure that there is productivity at work. And so, you might not transfer the standing desk, but you may, I've seen some photos of some friends who've got some pretty abysmal workplace setups, in a little tiny bedroom with, things stacked up on books, and that can't be super comfortable. So, to the extent you can, without kind of blowing the bank, I think that makes sense. Last question, anticipating constructive dismissal claims. It's really all about mitigation. So as long as you're treating people generally equally, we know there's going to be all kinds of constructive dismissal claims after this is all over. It's just, when you're taking widespread action that many employers have as a result of needing to keep their business moving, you're changing people's roles around. There's going to be litigation, that's for sure. The key thing is going to be in the defense is really mitigation. So people have an obligation to accept those changes, and unless the work environment is full of hostility, bullying, or is otherwise an intolerable work environment, then people have to stick around and they have to accept the changes. So just because they don't like it doesn't mean that they can just walk out the door, unless it's a really toxic work environment. So as long as you're, as long as you're not reducing, Sarah's wages and not Michelle's, or as long as you're treating people generally equally, that is the best defense. Or some companies have said, okay, so for those making 40,000 and under, we're reducing by 5%. Those making 80 and under, we're reducing by 10, and those making 150 or over, we're reducing by 20. Some sort of kind of equal-ish treatment that way is a good defense, because it's hard for somebody to say they were singled out and it was a toxic work environment if that's the case. So last chance for questions. Otherwise, that's it for me.
Are there any more questions, anyone? Well, Sean, you really provided us with a wealth of information. Thank you so much. There certainly were a lot of great questions asked here and important takeaways. There's so many details and different scenarios to consider that you brought up that I'm sure many of us have not even thought of yet, but they are going to come up at some point. So this has been extremely helpful. What I found it's a relief that the law is quite clear as to what is expected from employers to be able to work in a safe environment. And it was really helpful to hear that these protocols are in place. It's also important to be reminded that there are fines if a business is running non-compliant. So thanks for reminding us on that. On a positive note, there seems to be some opportunity here within the workplace for reorganization and scheduling. So it's an opportunity for employers to really revisit their business models and to create a more efficient and productive workplace. So Sean, thank you again. And I will just close by saying, as you may have heard, Family Business Atlantic, we are waiving our membership fees until August 31st for all new family businesses. So this will allow owners and family members to join virtual peer groups and to connect with our pool of advisors, Sean Kelly being one of them. And to also be a part of our programming that, as you can see today, is really going to be tailored towards the needs of businesses who have to operate during these challenging times. So if you or you know anyone who may benefit from these offerings, myself, Michelle, or Sarah would be happy to have a chat with you. I'll also let you guys know that we have a digital marketing course that has started today, and there are 3 spots left. It's going to run every Thursday from 1 p.m. to 4 p.m. for 11 weeks. So if anybody's interested in this, there's still a chance to sign up, and you'll be able to catch up on this week's course with our instructor, Mark Zerka. So please reach out to Michelle or Sarah ASAP to get some more information on that if you're interested. We will continue to provide more Staying Connected webinars, and we definitely encourage you all to check out our website, familybusinessatlantic.ca, for more offerings. And again, I invite you to join our coffee chats for some real-time conversations and help us build our family business community and share and like us on Facebook and LinkedIn. Well, thanks everybody. Enjoy this beautiful weather, and thanks again, Sean.
Thanks. Take care, everybody. Bye.
Thank you. Bye.